Let us move on now to the second protection offered by Article 20. This is the protection against double jeopardy. Historically, three pleas raised in a criminal trial by the defendant can be grouped together under the principle of double jeopardy. First, autre for convict refers to a plea that the defendant has been punished for the same offense. Second, autre for acquit is the plea that the accused has been tried and acquitted for the same offense. Third, autre for attaint is the plea that the accused has been tried and punished for another offense. All these pleas were raised to resist criminal proceedings on the ground that the defendant should not be put in jeopardy of life or limb once again. The last plea of autre for attaint has become largely obsolete in most jurisdictions. Double jeopardy protection is now restricted to prior conviction or acquittal. Article 20 Clause 2 grants the protection of autre for convict alone. Notice that for the bar to apply, a person has to be prosecuted and punished and not merely tried twice. So, if a person has been acquitted in the first trial, there is no bar against a second trial. Other constitutions protect against both autre for convict and autre for acquit. The Fifth Amendment clause of the US Constitution and Article 39 of the Japanese Constitution are examples. That does not mean that this broader protection does not exist in India. It exists, but only as a statutory right under the Code of Criminal Procedure 1973. In fact, Section 300 of the CRPC is much broader than the portion extracted here shows. However, it is not necessary for us to consider that provision now. We will restrict our discussion to Article 20 Clause 2. Let us identify the key features of Article 20 Clause 2 from a leading judgment. In S.A. Venkatraman, a 1954 judgment of the Supreme Court, the defendant and petitioner, a central government official, was dismissed following a disciplinary inquiry. Later, the state sought to prosecute him for offences arising out of the same transaction for which he was dismissed. The petitioner alleged a violation of Article 20 Clause 2. The court set out the conditions that need to be proved to establish a plea of double jeopardy. First, Article 20 applies only to prosecution of offences and not to inquiries and other proceedings. Secondly, the first and second prosecution must be for the same offence. Third, the earlier trial should have ended in conviction and punishment of the accused. Applying these principles to the facts, the court held that there was no bar to prosecuting the accused, as the disciplinary inquiry was a proceeding for determining service misconduct and not a trial for an offence. Similarly, proceedings initiated by tax authorities will not act as a bar against prosecution for an offence by a criminal court, even though both proceedings may be based on a common set of facts of tax evasion. Let us look at a recent case where these tests were applied. In the infamous Fodder scam, there was a general conspiracy to misappropriate money from the treasury using fake vouchers. Though the conspiracy connected them, separate sets of cases were registered for different instances of defalcation. After being convicted in one set of cases, the petitioner claimed in the second set of cases that a second trial for the same offence was barred. The court rejected the contention. It noted that while there was one general conspiracy, each instance or each connected set of defalcations were independent offences. Thus, the petitioners were not being tried for the same offence. It is fair to say that Article 20 Clause 2, while an important right, would operate only where there is clear unfairness or arbitrariness on the part of the state by trying a person for the exact same offence twice. Such occurrences are very rare.